I am Judge Patrice Ball-Reed, and I'm here with my co-host, Judge Jessica Aron O'Brien. And our guest today is Sandra Crawford. She is an attorney, and she is the principal in law, Crawford, PC. She's been an attorney for 25 years. She's also going to talk to us tonight about collaborative law. And she has been a past president of the Collaborative Law Institute. She was the past president 2009 to 2010. She is also a fellow of that same institute. She attended John Marshall Law School. She is also able to practice before the United States Supreme Court, and she has been a super lawyer since 2010. She's very involved in the Illinois State Bar Association, and she's also on the board of directors of the Illinois Bar Foundation. She's a great attorney, and we're so glad she's here. And Judge O'Brien is going to begin to interview her.
Thank you. Good afternoon, everyone. Good afternoon, Sandra.
Hi.
And welcome to our show. You seem to be the expert in this collaborative law, and it's a very interesting area. Why don't you tell us a little bit more about what is collaborative law?
Collaborative law is a practice of alternative dispute resolution, a non-court practice where parties come together with specially trained professionals, lawyers, mental health professionals, and financial professionals to, when they have a dispute, to put together a team approach to help them resolve disputes, particularly in the area of family law or in any case where the relationship has to be sustained after the dispute is resolved.
So just to distinguish it from a substantive area of law, collaborative law is actually more of a procedural way of resolving disputes, am I right?
Mm-hmm. It's a model of alternative dispute resolution. So if you think of the court as the primary resolver of disputes, the alternates are collaboration, mediation, arbitration, so a non-court process. Mm-hmm. So it's more of a process that's sometimes referred to as collaborative practice, so that distinction is made, collaborative practice or collaborative law.
Now, everybody who is involved in the collaborative law process then, is everyone a lawyer, or you don't have to be a lawyer?
No. Collaborative law is unique in that it's an interdisciplinary practice. So you have collaborative practitioners who are lawyers, you have collaborative practitioners who are financial people, and you have collaborative practitioners who are mental health people. So they're all credentialed in their own discipline, and then they take training in collaboration and also training in mediation so that they're able to practice collaborative practice.
Okay. And when you say training, is there an additional training then for attorneys to practice in this area of law? I mean, I'm saying area of law, but it's really not an area of law. It's more of a practice. Mm-hmm. Instead of litigating disputes, you're trying to apply a collaborative or a team effort of experts based on what you just said. Mm-hmm. Am I right?
Yeah.
Okay. And is there an additional training for that?
Yes.
Okay.
So in Illinois, we have the Collaborative Law Institute that sets standards for collaborative practitioners in Illinois. Mm-hmm. There's also the International Academy that sets standards. So the standard practice is a 15-hour initial training in collaborative and also a 40-hour training in mediation. So if you think of it as kind of a bridge, there's litigation, mediation, collaboration. So all of the practitioners in the Institute here in Illinois are both collaboratively trained and mediation trained, and that's part of, I would say most of the practitioners around the world are also mediation trained, as well as having the 2-day or 15-hour collaborative practice training, which is a very specific training in the model only.
So now when you litigate cases in the Circuit Court of Cook County, you have the Code of Civil Procedures, the rules of evidence that need to be applied. So in the collaborative law process, is there specific code provisions that the people who practice in that area need to abide by, or how does that work?
Well, we're still all abiding by the law if you think of the law as just one measure. So we still all practice in the shadow of the law. So you don't ignore the Code of Civil.
That. Shadow of the law.
Yeah.
Okay.
It's the shadow of the law. So we don't ignore the law. We just use the law as a tool. But there are specific standards of practice for collaborative practitioners using the law, it's a self-determination model. So if you think, I describe it to clients like this: you are divorced when a judge says you're divorced. That's the law. It's a status, a legal status. How you become divorced in the family law area is what we're talking about here. How you talk about the process of how you become divorced, how you enter agreements. 95% of all cases that are filed in the family law division end up in some form of agreement. It's just a matter of when. So in the collaborative process, we kind of front end that. Let's talk about your children, your future, your finances in a private setting, confidential setting, where the uniqueness is that the lawyers who take on collaborative matters also commit not to go to litigation. So we won't be your litigators. So we don't have that trap door, so to speak, to say, if you can't reach an agreement, we'll go tell the judge, we'll have a third party make the decision.
Why is that important?
It's very important for the lawyers, for the buy-in, right?
Mm-hmm.
It's way, I think, too easy for practitioners to say, if we can't resolve our disputes using all of our knowledge and all of the resources and all of the parties' goals and interests, then just to leave it to a third party to resolve it, leave it to the judge. Where the attorneys say, we won't go to the judge, we'll use all our skills and our conflict resolution training to help you reach a decision that's not made by a judge, but is made by the parties themselves. And in the mediation literature, you will see much more sustainable long-term agreements, which is both good for the parties and good for the system at large. We do struggle with funding of our court systems. So taking those families out of the court system and allowing them to have a private place to reconcile their differences. Not everybody, it's not going to be for everybody, but 95% of cases end up in agreements anyway, so there's a lot of agreement going on. It's just the attorneys in collaboration are committed to that agreement, and we won't fuel the fire by saying, let's pull the plug too soon on the agreement. So that's our commitment, our professional commitment.
How long have you been practicing in this area?
I've been practicing collaborative since 2002 when the first training came to Illinois. But I see kind of my journey to collaborative has been, I was trained in mediation in 1994. I've litigated throughout my whole career. So now I'm able to give my clients a choice. Right? I say to them, door number 1, litigation. Here's the pros and cons of that. Door number 2, mediation. There's pros and cons to that. And door number 3, collaboration and the pros and cons to that. So clients from the outset are choosing their process. They're empowered. They see the value of self-determination and not to leave it to a judge who may make a decision that neither party can live with.
Okay, well, we're going to take a break now, Sandra. We're going to have some more questions for you after that break. Thank you.
Pretty much a good day for me would be people leaving their hands off of me. I'm always called names. Everywhere that I go, there's always someone calling me names, calling me gay. I've been choked, thrown up against a wall, punched. Nobody's ever tried to help me.
Well, we took a break and we're coming back to talk with you again about collaborative law, Sandra. And so you've been involved in it since 1994. You started with mediation, then you started doing collaborative in 2002. What is the history of collaborative law in Illinois, as well as how you decided to do that?
So two questions. The history, collaborative law, the concept is the brainchild of Stuart Webb, a Minnesota litigator who had basically burned out. Stu wrote in his diary in January 1990 that if he could not change how family law was practiced throughout the world, that he would kind of pack it in, would give up practicing law. Because he described it, he said, every day he would go to the office and he felt like he was a cowboy coming in the Old West, coming to the homestead and putting his hat on the stick and to see who would shoot at it. And he said it was very stressful for himself and his clients. So he had really looked for a different way of practicing. So in 1990, he declared himself a collaborative lawyer. And from that now has grown There are practitioners in all 25 countries around the globe, in all states in the United States. It's grown to an international organization, the International Academy of Collaborative Professionals. So in Illinois, there was a few professionals who, like myself, had been mediation trained and had kind of started to hear about Stu's work, and then Stu had connected with some mental health professionals in California who were also doing the same kind of work, wanting to change how family law was practiced and also change the outcomes specifically for the children, because the outcomes with respect to children, there's statistics and research on it, can be very devastating for the family and for the children, and historically. So in the collaborative practice training, the first training here in Illinois was in 2002, and I was very lucky to be part of that training. And our initial training did include attorneys and mental health professionals. So, and then it grew to include financial professionals too. And as I said, all of those professionals have designations and long-term experience in their primary professions, and are drawn to this probably because they feel the need of that litigation is not serving these families. It's not helping them have sustainable agreements. So the history here in Illinois, the Institute started in 2002. I was very lucky to be part of the initial training. I now do training myself of professionals with a team because it's a team approach. And as I said, it's grown worldwide. There's applications outside family law that are practiced in other countries, but we're still new ground here in Illinois, and I'm hopeful that'll grow outside the area of family. But our institute was founded by family lawyers, so it's particularly family law centric. There's also the CPPIL, Collaborative Practice Professionals of Illinois, who also, there's an organization that has a broader scope outside just the area of family law.
But so collaborative law does not just apply to family law, right? I mean, there are other laws, other areas that the practitioners in those areas, like the probate, is that right?
So the practice of collaborative law has applications in other areas, probate, small business disputes, especially where you have family-owned businesses and closely held corporations. So how I describe it is it's appropriate where once the dispute is over, the parties still want to maintain their relationship, right? They want to resolve their dispute, but still not destroy the relationship because of the dispute resolution model that they choose. Sometimes in litigation, because there's a winner and a loser, that is going to impact the relationship long term.
And when you talk about relationships, though, in the context of family law, you're talking about where kids are involved, right? Where the relationships, obviously, even if the parents are divorced, you have the parents still have to deal with the kids together, right? And in probate, you have the estate, and then when you talk about small businesses, you're talking about the ownership of that organization or the corporation. The corporation needs to continue, but the relationships also still have to continue, and is why collaborative law is even more effective as opposed to going to litigation.
Well, because you preserve the relationship. It's that old adage, you know, the operation was a success, but the patient died. Sometimes in litigation, you know, yes, there was a successful outcome for one of the parties, but it ruins the relationship long term. If you think about probate matters, it usually involves family members, so it has an impact on the wider circle of family. If you've got a small business that's family owned and they get into a dispute, you know, it might impact the relationships in that family or that community and have long-term repercussions.
But would you say then that the basic premise of collaborative law is more relationship, preserving the relationship, or is it cutting down the cost of litigation, or?
Well, I mean, there's a lot of aspects of it. The International Academy of Collaborative Professionals, IACP, undertook a 5-year study about costs and what cases were appropriate and what cases were destined to fail and why they were destined to fail. Now, that study is now about 5 years old, and there's other studies ongoing regarding collaborative practice, but it has to do with cost and sustainability of the relationship once the dispute is settled. And not only, I mean, yes, where children are involved, but I have a lot of cases where it's couples who have never had children. So but they have extended.
The dogs and the cats.
Yeah, yeah, and there was.
But how do people decide to get in the process? Who do they ask? Where do they go?
Well, education is a concern. It's been a challenge to educate people, but I think now that we have the internet, folks do a lot of research about models. A lot of clients come to me because they have been referred. They have they've known about disastrous outcomes from litigation, and they know that they don't want that. They just don't know what they want. So a big part of the role of a collaborative professional across all of the disciplines is education. Education is key because then we inform the clients because they need to have informed consent. They need to make sure that they understand the pros and cons of everything so that they can choose.
Okay, so we're going to take a break now, and we'll talk about what the future holds in terms of collaborative law.
So they say it's a man's world? I don't see anybody's name on it.
While they were doing their thing, we slowly changed ours.
Today, women can do anything men can do. And there's one thing we're even better at.
We've been talking about collaborative law, and what we're going to talk about now is the future of collaborative law, and as well as finding out how you can actually talk with someone to find out more about it or participate in it. So Sandra, can you please tell us that?
Well, there's a couple of ways. I would say the quickest way to get information about the model and the practitioners worldwide is just to go to www.collaborativepractice.com. All of the statewide and national members are members of the International Institute. So that will be the resource for trained professionals who have a commitment to doing this process and doing it well. The standards, the IACP standards, are heavy on a lot of continuing education. So if you, the Collaborative Law Institute of Illinois is a member of the international organization. I sometimes describe it as we're like stacking dolls, Russian stacking dolls. We're all within one another, and then you get down to the individual practitioner. But most of the people who are practicing this model have a dedication to conflict resolution, to problem solving, to good outcomes and sustainable agreements. And I think there was another part of your question.
The other part was the future of collaborative law, but I'm gonna have Jessica read a testimonial, and then we'll further talk about the future of collaborative law.
Well, certainly the first time I think I heard of collaborative law, I mean, I'm linking it with you because I think you're the first person who really told me about it. And you speak so much about this subject that this is great. And I think it looks like, number one, it's another option for people. And number two, it seems to be working really well for many families, right? And here, let me just read this testimonial. We chose the collaborative approach with our divorce because we wanted a respectful process. We did not want our future joint parenting relationship to be adversely affected by litigation. We were active participants in the final settlement, as opposed to having the judge decide the outcome. Of course, for us judges, anytime other people want to get involved and have an amicable resolution, we're always grateful for that. The team approach of using attorneys, coaches, and financial specialists was very helpful and educational. It was obvious that the goals of the whole team were to solve problems rather than to create them. So that's a very interesting testimonial of a family, the couple, they were married for 21 years, and they chose this approach and was very happy with it. So tell us a little bit about the future of this approach or this law.
Well, I think it's here to stay. There is law, the Uniform Commission, the Commission on Uniform Laws in 2010 released a Uniform Collaborative Law Act, which I think it's now 12 states have adopted. It is pending here. Illinois Senate Bill 2735 is the Uniform Collaborative Law Act for Illinois, and we're hoping for passage of that act. And that just embodies the tenets of the whole idea of informed consent, respectful resolution, disqualification, voluntary disqualification of all of the professionals if the parties want to go to litigation or threaten to go to litigation. But there's a big learning curve for parties. I mean, I think a lot of clients come to my office and say, well, let the judge decide. Well, they don't realize that they probably aren't going to get in front of a judge for 18 to 24 months, that the judges are not going to want to decide every issue that may impact a family now and in the future. So it's that testimonial covers a lot of it because it's about respectful communication, teamwork, the professionals acting as problem solvers and not in the traditional role of advocate, which may inadvertently cause more conflict than it resolves.
But you're saying hopeful. Why would anybody oppose it if it's another
I think there's
approach?
there's a lot of education still to be done within the professions as well as with the public. I think there's a lot of concern, as I've heard it, about the disqualification provision, and I think there's just a lack of understanding that I voluntarily have chosen to practice this way because I've seen the outcomes in litigation, because I've seen the outcomes in mediation. It's a choice by the professional to say, I want to practice this way, and it's a commitment to families and sustainable outcomes.
So this is an act that the group wants to propose at some point, right, in Springfield.
It is proposed.
Is there a draft or proposed
yes,
bill at this point?
It is Senate
Okay.
Bill 2735.
Who's the sponsor for that?
Right now it's Senator Mike Nolan is our sponsor
Is
in
he
the
an
Senate.
attorney?
I believe,
Okay.
I believe Senator Nolan
Well,
is.
how does this act, though, differ, or how is it similar to the Illinois Marriage and Dissolution of Marriage Act that was, as you know, has recently been effective January 1st?
Yeah, so the Illinois Marriage and Dissolution of Marriage Act that was revised substantially and went into effect in January is the governing body, is the governing rules regarding divorce and what the courts have to take into account during divorce. So it's kind of the umbrella. The Uniform Collaborative Law Act just describes the process, what the public can expect from professionals, what the act itself was created by a collaborative effort of folks from around the world. And it just describes what the expectations can be for in terms of education, in terms of process, in terms of professionals disqualifying themselves. So it gives the outline of a process, and also says, as a collaborative practitioner, you have to advise clients of all of the different opportunities and models available to them so that those clients will be empowered and will then be able, in a self-determining way, to make a choice about their process and not then be, at risk of saying, well, I didn't want to do it this way. So there's an affirmative obligation within the act that professionals have to advise of all models.
But I just want to be clear, though, the people who practice collaborative law are lawyers as well.
There's
right?
lawyers, there's mental health professionals.
No, but the team has all of
Yes.
those professionals, but the people who are actually discussing the legal aspect of family law, for example, are lawyers.
Yes.
I guess the reason why I'm saying that is when I ask what is the opposition, what would be a potential opposition, it wouldn't be because people who are not licensed attorneys are practicing in this area, right?
It's not the
Okay,
unauthorized
all right.
practice of law.
Got it.
No, each
Okay.
party.
So that's important.
Let me just describe how a collaborative process looks like in real time. There is a collaborative professional, a collaborative attorney for each of the clients. It's the team then includes mental health professionals and financial professionals, because especially in a family law, you have the legal concerns, the emotional concerns, and the financial concerns. So the professionals from each of those disciplines can talk very specifically about the nuances of those disciplines and really serve as a net to shore up the family, so they can then, the families, the participants, the spouses, can make their own decisions about things that impact legally, financially, and mental health.
Which is an interesting concept and approach, given that you're engaging professionals in all these areas and not relying on a judge to be an expert in all these areas.
Yes, exactly.
Well, Sandra, can you give us a final word, because we're about to close out the show?
I think collaborative is the wave of the future. I think with the rise of the internet, people are definitely looking for more cost-effective, sustainable ways to resolve their disputes, to have more input. I think in this day and age, people want to know how things are going. They want to manage time and costs, and they really do want. When I to a person, every time I've described this to people, they say, "Oh, I wish I'd known that when my brother was getting divorced," or "I wish I'd known that when my cousin was getting divorced," or my friend down the street. So I think it is the wave of the future in terms of how conflicts are going to be resolved in our society as we go forward.
This is exactly our goal, is to bring all these new approaches, new law to the public. But thank you so much for being here with us.
I appreciate the opportunity to talk about it. It's my passion, and thank you guys
Yes,
for
we
having
will.
me.
Thank you,
Thank you.
Sandra. And thank you to the audience for listening to us. You have had a presentation on collaborative law, which is associated with the Women's Bar Association of Illinois cable show. We appreciate your attention. Have a great day.